There
Hi,
we go.
my name is, yeah, there we go. My name is Mark Monlux, and this is another episode of Law and Artist. I'm a freelance illustrator, and for years I've taken my legal questions to Daniel Abraham.
I am Daniel Abraham. I'm a former freelance illustrator, currently a lawyer representing artists of various types in various situations.
And
shall we pick up where we were before?
First, a disclaimer. Oops, just a moment. Okay. Law and Artist discusses general principles of law in response to issues of concern to the illustration community. Nothing in this video or in the Law and Artist comments should be construed to be a substitute for advice of legal counsel regarding the specific facts or circumstances of an individual case. Laws and their interpretation differ from jurisdiction to jurisdiction. Legal advice advising a specific situation should be sought from an attorney duly licensed in the appropriate jurisdiction. And this week we're going to be talking about, again, on derivatives, and we're going to be talking about how it's not just from visual art to visual art you have to be concerned about, but hey, books get made into movies, art gets turned into sculpture, and we're going to be talking about some of those derivative cases.
Okay, Mark, I'd like to make the point that the sole right to control derivatives is one of the rights, that's the part of the bundle of rights that copyright gives you. That bundle of rights which we discussed in an earlier episode here, which you do not really get to access unless you have registered your work. You've got to register your work to be able to enforce all of these rights. I want to underline that because it is something that not enough people do, not enough people remember. And okay, here we go. We've got a picture here from a very famous case, Rogers v. Koons. We see on the one hand a photograph of two people with a bunch of puppies. Jeff Koons took this photograph, which he picked up, I believe, in a card store, sent it to the people who do his sculpture for him in Italy, and gave them instructions on what he wanted them to do with the image, the colors, making the people look geeky, etc. And he tore the copyright notice off of the card on which all of these instructions were written. And the photographer saw this and said, that's my photograph. You have translated it from a photograph into a sculpture without my, and this shall not stand. He sued Koons. Koons lost because partly because he had, of course, been so blatant in his disregard of the copyright, partly because he was making a derivative work from one medium to another without permission of the original artist.
But Daniel, isn't this, something that's fairly common, especially in the music industry? I mean, tell us about the Two Live Cruz case.
Well, the Two Live Cruz case, well, there is a lot of borrowing in the music industry. There's a lot of borrowing in all arts, actually, but it has to stay within certain reasonable bounds. Two Live Crew case, Two Live Crew versus Acuff Rose, was Two Live Crew doing a rather profane version of Roy Orbison's famous song Pretty Woman. And Acuff Rose Music, which owned the rights to the Orbison song, sued Two Live Crew. The Supreme Court decided that this was a parody, which gets us into from derivatives over into the fair use area, which is very, very complex, and decided that as a parody, it was permissible. This leads us to a problem, which is that they called this a transformative work, and transformative is anything that the judges say it is.
So it's almost sheer it almost depends on what judge you have and what type of argument you can place forward to them as to whether or not they're going to finally determine whether or not it's a new form of art.
When you start getting into the issue of whether something is transformative, which is gets us, as I said, away from the derivatives, strictly speaking, and into fair use, which is how much you can transgress on that right to control derivatives, it is very much up to the judges, and it is a terrifying thing sometimes that to have judges making aesthetic judgments.
Now, if you mentioned before that you heard that once again Coombs was
Well,
I think that's a buzz on your end.
it appears to be, but I have no clue as to. Well, it does not matter. This is somebody apparently trying to send me a fax. Who knows? Who knows?
You were mentioning before that Koons recently was involved in another case, but this time Koons won. Do you remember this?
Yes. Well, what happened was, yeah, I cannot recall the name off the top of my head. However, that a photographer had taken a picture of a woman's legs wearing a pair of gold slippers and had gotten the usual paltry editorial sum for doing this for a magazine. It was part of a a magazine spread, and I think Vanity Fair. Koons took these legs and a number of other legs and had one of the people who do his paintings for him paint these legs over, I believe, a hamburger. It was supposed to be some sort of cogent comment on, objectivization of women and things like that. And the photographer recognized her set of photographed legs in the in Koons's collection of legs, sued him, citing Rogers v. Koons. And because the Two Live Crew case had come along where they said, okay, this is a parody and therefore transformative, she lost. She lost. So this shows us how the growth, the creeping boundaries of fair use, which is a whole other topic, is encroaching upon your right under the copyright law to control derivatives.
So we might come back and talk more about derivatives at a later time, but I think that's going to wrap us up for this week.
I think that's a good place to leave it. We can revisit this in the future.
Okay. Thanks again, Daniel. I'll see you soon.
Always a pleasure.